Emeka thought he had made it. He paid 4.5 million for a plot in Ibeju-Lekki, got a stamped document, and celebrated like a new landlord. He framed the paper, posted it online, called family to rejoice. But the truth was brutal. That paper did not mean he owned land. It only meant he had been assigned a plot inside an estate. In law, those two things are not the same. Before that day, Emeka had saved for 3 long years. He watched land prices keep climbing while he waited patiently. So when the developer handed him an impressive-looking allocation letter, relief washed over him. The signatures were there, the stamp was there, the plot number was there. To Emeka, it felt official. It felt safe. It felt like ownership had finally arrived. But an allocation letter is not legal ownership. It is usually an internal document from a developer showing that a specific plot has been assigned to you within an estate layout. That is all. It does not automatically give you government-recognized title. It is not the same as a certificate of occupancy. It is not the same as a registered deed, and it is definitely not the same as perfected land rights. If you walk into a bank with only that paper, the bank will not celebrate with you. Lenders do not price vibes, they price risk. They want registered title. That is where many buyers get trapped. 2 years later, a section of Emeka's land came under dispute. Boundaries began to shift. Another buyer showed up with his own paperwork. Emeka returned with his allocation letter, expecting it to protect him. It did not. Why? Because the letter did not prove the land had been lawfully tendered to him. It did not settle ownership. It did not lock the land down. It simply showed that at some point the developer assigned a plot to him. In plain language, think of an allocation letter as a receipt of assignment. It tells you which plot number was given to you within the estate. But if the document says subject to survey, pay attention. That wording matters. It may mean the exact boundaries are not yet fully fixed. So yes, you may have a plot number, but no, you may not yet have the kind of title that can defend you in a serious legal fight. And in places like Ibeju-Lekki, this mistake can become very expensive. Some lands sit inside old government acquisition lines. Some have excision questions. Some are still surrounded by multiple claims. A plot can look peaceful today, then become a problem tomorrow. That is why the smartest buyers never stop at the developer's paper. They ask the hard questions before money leaves their account. Start with the root of title. Ask, what gave this land its legal life? Is it a certificate of occupancy, a gazette, a registered deed chain, or a valid right of occupancy? Then run a search at the Lands Registry or Lands Bureau. Do charting with a surveyor to confirm the land is not inside acquisition or overlap. If excision is claimed, verify it properly. If gazette is claimed, confirm it too. Check that the developer is a real company with authority to sell. And when the time comes, perfect the title through deed registration, stamping, and governor's consent where required. Even then, stay alert. In Nigeria, even a C of O is not magic by itself. It is important evidence, yes, but serious buyers still verify the route, the survey, and any competing interests, because land does not reward hope, it rewards proof. So the lesson is simple. An allocation letter may start your journey, but it does not finish it. It is step 1, not the finish line. If you buy land with only that document, you may be celebrating a promise instead of property. That is why at F.A.R. Properties, every serious buyer must choose due diligence before pride. Check the title, check the survey, check the history, then pay. Verify title before paying for land.